open the Town of Mendon Zoning Board of Appeals meeting. Just for those who are online, this meeting is being recorded. We have in front of us the minutes of January 13th.
I can make a motion about the minute, approves the minutes of January 15th.
Second.
Roll call vote, all in favor?
John? Yes.
Tom, aye.
Matt Clark? Aye. Minutes are approved. Okay. I'd like to continue the hearing from 43R 8th Street. Variance request. Maybe represent the applicant.
Good evening, Mr. Chairman. David Bertazzi with me again is David Fernandez, the applicant. So when we were last together, the board had heard back from town council and was looking for some legal support for the zoning relief that is requested by the application. So I wanted to start with your bylaws. So in Article 1, Section 1.02 of your bylaws, you provide definitions. And one of them is the definition of frontage. And the provision reads, a continuous line measured along the front line and between the points of intersection of the side lot lines with the front lot line. So there's no mention in there of the word street. There's no mention in there of whether making any kind of differentiation between a fee or ownership interest and easement rights. There's a subsequent provision in your dimensional requirements that talks about how frontage is to be measured, and that provision doesn't make reference to streets. But again, there's no differentiation between an ownership interest or fee interest and easement rights. In your bylaws, there is no requirement, nor is there one in the statute, that all lots have to have frontage on a street, nor is there any requirements that having frontage on a street is a requirement for the grant of a variance. So that's what leaves you with the requirements in the bylaw for the grant of a variance, which mirror what is in the statute. And that is that owing to circumstances relating to soil conditions, shape, or topography of the land or structures, and especially affecting such land or structure, but not affecting generally the zoning district in which it is located, literal enforcement of the provisions of the bylaws would involve substantial hardship, financial or otherwise. So I would suggest to you in this case, that is met. The circumstances that result in this lot being unbuildable or the substantial hardship are this odd configuration. You've got a parcel that is many, many, many times the area requirement in the bylaw. It is connected to Main Street by that thin tail. And this parcel, as we discussed previously, was created in this manner in 1950, prior to the enactment of zoning, and done so with the understanding, and so this was a family transaction where one of the family members ended up with this lot while others ended up with street front lots. This was done with the understanding that right of way provided access and did not affect the buildability. Is that right? The buildability of this parcel. Otherwise, this family would not have rendered all of their real estate unbuildable. And so there are a number of court cases that are out there that sort of stand for the proposition that a deficiency in frontage in and of itself cannot be a circumstance related to soil condition, topography, and shape. But those decisions, I would suggest to you, are distinguishable from this case. And that is because first of all, the zoning bylaws that are being considered and examined as part of those court decisions are different than your bylaws. They have more detail, they have different requirements. Many of them requiring frontage on a street for all lots, and that's nowhere in your bylaw. In many of those cases, you have just a basic square or rectangular lot that's similar to all the other lots in the zoning district, just doesn't have enough frontage. Or you have situations where you have self-inflicted or self-imposed decisions that are made by landowners after the advent of zoning, and with an understanding that in making those decisions, they are affecting the buildability, I'm going with it now, the buildability of the parcel. That's not the case here. This is not like many of the cases that I suspect town council provided to you when you asked for direction. I would suggest that this case is more on point with the decision in Crosby v. Board of Appeals of Weston, which can be found at 3 Mass Ave Court 713, 3 Mass Ave Court 713. And in that case,
This is probably.
Crosby v. Board of Appeals of Weston. And in that case, the grant of variance was upheld where the locus was originally laid out in conformance with requirements, or in this case, prior to the enactment of zoning. But subsequent zoning amendments, or in this case, the enactment of zoning, or subsequent amendments to that enacted bylaw, rendered it unbuildable. So I would suggest that this is more along that line than a situation where the hardship is not caused by shape, topography, or soil condition, but it's just simply caused by a lack of frontage. That's not the case here. So with that said, we're happy to try to address concerns that the board might have. I have a copy of that if you'd like.
Yeah, I have to, let's just leave it. And then if you say that, we have it right here. Just want to see that definition.
I have the bylaw here if you'd like to look at it. The definition section 1.2, I think it said. 1.02 subsection 2. If it is the desire of the bylaw to require fee frontage on free, the bylaw should provide.
No, speak to my concerns. So in approving this variance, we would be interpreting our bylaws in a new way than has been interpreted in the past. I think John, you mentioned
I don't
last.
think the whole bylaw has ever been presented this way. We've never had a lot presented with zero frontage.
The
only one I have ever had.
An unusual circumstance, and you're probably not likely.
We did have one,
Okay,
zero frontage, but it was, he was gonna use his existing driveway as a means to the house. You know, and then it wasn't 6 acres, it was only 60,000.
you know, and then the question becomes, when was that created?
That's right.
In relation
That was recreated after zoning to have the fairly new house.
So that's a whole different,
That's right, that was the whole
so if you're
thing.
concerned about precedent, you gotta
Yeah, that's what,
square a hole that someone's gonna be trying to put around.
that would have been a precedent setting.
I don't think we necessarily need to interpret the bylaws in that. Because I think what you're suggesting is interpreting the frontage requirement,
I can understand this, yeah.
whereas if it predated zoning.
Yeah, because there's a lot created before zoning. You know, and when you're gonna build one house,
That's all.
only be one house there. It's 6 acres, you know, who knows, in 10 years, 15 years, somebody could put a road through it, because there's plenty of frontage here.
And again, just as a reminder, the proposal is to divide the parcel because we, 3 months ago, I think.
That's right.
Last year, to divide the parcel and to convey a portion of it, which would further reduce the size of any remaining land
Yeah.
and the threat of future
No, that's-
development.
Yeah.
And also create a buffer for some of the neighbors that might be affected.
As zoning laws change, over time, they're gonna change.
Yeah.
And who knows, we get one lot there now, because this is 3 acres. You could put 2 or 3 houses, probably a couple of years from now. Put a right of way through there, a common drive, or on one of these other lots if they
Yeah.
wanted to. They're actually preserving land.
Yeah, and the land is off appropriate.
That's what I'm saying.
And this board could put conditions.
That's what I'm saying, you do that
To
one
ensure
lot.
more development of these
So,
I'm just looking in the future.
sorry, is this a special permit or?
areas.
Yes, kind of, where does it fit?
Well, because, so I understand just looking to, going through the bylaws and looking for the word. And. Well, okay.
There is another provision in the dimensional requirements that talks about measuring it. And in that provision, there is reference to measuring along the streets, continuous streets, but it's more how we measure it on a cul-de-sac and things like that.
But there's also,
Definition.
there's another section where it says, when, applying for special permits. As well as there's variances listed in here as well. It says. Each lot used in part or whole. I guess this is for a business shall have a minimum frontage on the street.
Yeah, and again, these things come together piecemeal. You have something that was enacted in 1960 and those provisions are still there and you add them in and
Oh, I see where you're at, the dimensional, in all districts, any driveway shall be wholly contained within said lot. Service and access shall be contained.
so there is a provision in there that talks about measurement, but it's more measuring in continuous lines and on cul-de-sacs, how you measure and things like that more than being definitional.
Yeah, I think on the definition of
Yeah.
frontage for the measurement piece, I get that.
Yeah.
It's the public. I think
Access, yeah.
we need to stay away from that piece.
Yeah,
With
This is a unique lot that's created before zoning,
I think that's that would be more of
and you really can't landlocked say you can never build on it. Really. No,
Ultimately, would probably be combined with something else.
that's what I'm saying, it's gonna get combined either today or 10 years from now, 15 years, sometime.
So that doesn't help this landowner.
No, I'm saying that's the future. That's what I said, I'd rather build one house, be done with it, than come back 5 years from now and say, we're gonna put 5 houses in here, 6 houses.
Yeah.
You know, if
I
they
mean, I
get
think that would be that for the
town
town.
water, town
That's the
sewer,
environment.
it's gonna happen.
It'd certainly be wonderful for, yeah.
That's the way I look at it, that's my opinion.
So, but, hang on, so. What the concern is that we were afraid that we'll get 6 houses in there, 5 houses, or more than one?
Not now. 5, 6, 7 years, if they change zoning, if we get town water, town sewage, they've already got town water there. But not in this lot, who knows? Coming down the road. It could,
Yeah, if
That's still a stretch, but.
it's a stretch, it is, I couldn't see, you see maybe 3.
I
I
mean,
mean, our point is that there's hardship that flows from
Yeah.
the literal enforcement of the bylaw as it relates to this parcel. What future development they could be.
no, I mean, and then I would. It might happen that more than.
What about the other 3?
But my concern is, so, my concern is just that the. I'm sorry, can you guys, what were you discussing, I'm sorry, I was reading it, about the previous frontage? The previous one was granted with 0 frontage?
It was never granted. Because that was created, the house was built after zoning, and he wanted to use his existing driveway as frontage for the other house, and he didn't even have 200 foot of frontage.
Okay.
He didn't have,
Well,
enough-
I think it wasn't.
he needed 2 variants, he needed one,
Behind me,
but his lot that we granted when he built it, now he wants to put a house in the back, he used his driveway for another house in the back.
if we're using the right of way as if we're considering this frontage, like how much frontage should we have? Just how much?
20.
Plan
15 feet, I think.
15, so.
And again, it was straightened out
Yeah,
to provide better access for emergency
or
vehicles.
15 and a quarter
Because
feet.
it was formerly a zigzag along the front sort of left-hand
I don't
boundary line.
think you can count that technically as frontage. I think what we're saying
No.
is the creation of the lot predated the requirement for frontage.
So we're talking about,
Isn't that-
Because that's not frontage. So
But
right
I
away,
don't
we might be
make
frontage.
that decision. I didn't say that you have.
but we're gonna, like, basically the question is, are we going to grant it with?
Yes.
So we talked about the, the financial hardship or substantial hardship. I think we discussed the public goods last time. About the shape or topography. This, considering the lack of frontage as a unique shape or topography seems to.
That would be, that'd be the same.
That's not like,
It's not the legal place.
we're saying it's this configuration with a parcel that is, many times the required area to the rear connected by this strip of land to Bay Street. So it's that shape and configuration, which again was created, but nobody cared. But it is, then it created the hardship. When it was created, folks said, we have access to the property, we can allow us back there tomorrow. But that doesn't fly now.
So just slightly related, but that parcel adjacent at the back, this brook parcel,
Yeah,
is that developed? That looks like it has the same condition. Doesn't it?
I think it belongs to this guy here. It's the same condition, yes.
This,
The Brook parcel, it'd be off of them,
That's off of Edwards Road.
off of Edward.
So Brooks want that piece of land from him, that's his business.
oh,
He has an abutting parcel that has frontage.
Yes,
yeah, okay.
The owner of that little piece that's in the front.
Brooks' house is on that. Yeah, he bought that piece from here.
Was that, did you subdivide, was that just always a separate lot or was it subdivided? That,
That was cut out of the main lot.
Yeah.
That's me. I remember when they did that. This house is over here, this is only a driveway.
So, let me ask another question, and I hate to leave you with the water, right? So the variance is for frontage, right?
It's lot width through which it runs, I'm sorry. No, because I think you could do lot width because he's gonna be far enough back. Yeah, so I think it would just be frontage.
So. There's all, then you have the issue of the driveway, right? Any driveway shall be wholly contained within said lot not being serviced. Sorry, said lot being serviced, and access shall be contained within the limits of the said lot's frontage. On an accepted public way, amendment, no driveway should be located closer than 10 feet to any side lot line. So this is,
Which division is that?
subsection 2.01. Hold on.
Sorry.
SS 2.01. Section 2.01B. if you want.
This is right away, it's still gonna be owned by Stephen Wright.
Yes.
That's currently deeded now.
Yeah, so section 2.0 of the resident regulations, any driveway should be wholly contained.
Now that's right away. You're just creating that. That's not an existing right.
It's existing, no, it's existing.
It's an existing, all right.
That was created back in 1951. Well, I used to be on one big parcel of land.
Yes.
Stephen Wright's and my property. It was all one.
Yeah.
They decided to build a one house lot on 15 Bay Street, and they left 15-foot easement to get to the other property.
But that has been reconfigured so that it's no longer, it used to run along, I think.
Yeah, I can, yeah, we.
So that new one has been done. He's relinquished his, Mr. Fernandez has relinquished his right to the zigzaggy one.
Yeah.
And the one that's depicted on that plan
Is a real,
is deeded to him.
How long have you owned the property?
I bought it from Molinari back in '06.
Oh, and I did it.
The deed, the right of way used to be in his name. When I bought the property, the deed came over to my name. The right of way.
with the right of way.
You bought it or after deed on
I bought it, yeah. I bought the land, so the easement automatically came right up.
With the land.
And what were the representations relative to buildability at that time?
So my understanding last time when I came up here, they had an issue of like a fire truck and just going through the other easement. And it was talked, we actually had one of the meetings on the property. And, they had stated a concern on fire trucks or, going through there, and my lawyer suggested on moving the easement the right away, so that wouldn't be an issue.
Yeah, so you could get in.
He understood he needed zoning relief.
Yeah. I understand that. That's been one of my questions. The fire department. You have to go through them anyway.
Right. So that was brought up back in time. And
Yeah.
And so that is why we reconfigured the easement so as to eliminate that as a concern.
This is the second or third time this lot's been brought up in zoning.
It's the second,
By you, but it might have not.
I don't know, it's the second
That's what
time.
I'm saying there.
Yeah, just, my first time was when with cattle all out, and then this is the second time.
I was on the board then too.
That is a variance request at that time, or?
Yes, it was a variance, it was
Yeah.
variance request. It was a similar request. I don't know, there was no portion of that to give the property, a portion of the property away to the buffer, which is a straight variance.
it.
Did the variance request stated for frontage or?
Yes, it's
Yeah,
about the same
right.
range, but the right of way was different.
I wasn't involved in that. It wasn't with me.
That was one thing.
So it would be a request to vary,
Zero frontage with a 15-foot right of way.
so relief from the frontage requirement. And then relief from the
Driveway,
driveway, offset the driveway.
wholly contained driveway, wholly contained in the lot.
I just, I feel as though, based on the council we received, that going forward with variance applies in the base record does not, trying to think of the right word here, it just does not jive with the interpretations that our council has provided us. And I would feel more comfortable either bring this new information to them, getting their thoughts, or not going forward.
So when I was here last night,
What was the new information?
But if this case law that we were given, that because, I mean, yeah, this case law we were given, and
so I asked last time we were here for sort of some of the information that you were receiving from council. It's hard for me to comment on what your council is telling me if I don't know what they're telling you. So I had asked for that and was told that I couldn't have it. If there are certain cases that you're concerned about and you can tell me what they are, I have perhaps reviewed them and I can comment on why I feel that they're distinguishable.
I think this, so, and this is what I was getting at, like, I agree, if we are varying frontage strictly based on existing frontage,
this is mostly,
is Perez, right? That's the one they meant.
So, well, why can't we give them case law that we would give?
So this, what the Crosby case is suggesting is the subsequent zoning amendment, in this case zoning area, right?
Correct.
And unbuildable. So what I was getting at is we want to, I think what we want to look at is the lot as it was created before zoning, yeah, but it was buildable then.
And you want to look at the other cases that town council is citing, if they, in that case, someone did something like the last petition that was in front of you, or it's a square lot that just doesn't have enough frontage, or the zoning bylaws that the court is interpreting are different than the zoning bylaws here, then, it's distinguishable. If you're just getting a blurb that says, that, a lack of frontage in and of itself is not a circumstance owing to topography, soil conditions, or shape, you're not getting what the case is about. So, you need to actually look at the case and see whether the facts of that case are distinguishable from this application. And so because I don't know which cases you're looking at, it's hard for me to try to distinguish them for you. And say that, but from, what I'm seeing, this Crosby case go in line with what we have here. You have a circumstance where a lot was created that was buildable, that was rendered unbuildable by subsequent zoning enactment.
I think what we could suggest here without voting, that would be, is, yeah, because I don't have the benefit of the deed and
Yeah,
show that this lot was created, to follow the Crosby case, the same thing like that. It was created in conformity with zoning or lack of zoning at the time as a buildable lot. And then show that the documents when that zoning enactment changed, accessibility, essentially buildability of this.
Yeah.
If we have that, I think we have this precedent to follow. It's easier to. So if,
Can I see that? If I'm trying to see why I might have to read for you here.
so then if it met the requirements of zoning change, there was a variance required for.
Well, there were no requirements. There were.
this
Zoning
was,
didn't
law was
exist in
created
the
before zoning,
So then it's.
so it's kind of grandfather.
I wasn't wondering, I said.
Yeah.
The grandfather,
So here's a deed from 1955.
Yeah.
It first created it.
I don't know when.
And so there was no zoning in 1955. Zoning wasn't enacted until 60.
The benefit.
Okay.
They have a stance that. No, it's different, so
if that's if they're seeking relief from the zoning, right?
well, because they've been told they can't.
Because zoning laws came in after the law was created.
So I guess
Well, so we do need relief from zoning laws because they have been since enacted.
But, okay, but Judy,
Yeah, that's what I'm saying, you actually.
so it's pre-existing non-conforming.
That's right.
But the house had been built in 1955 we'd be all set, but the house wasn't. Now we're applying for an application for a building.
But it's
I just
lot
like to say,
still buildable because pre-existing non-conforming is why, if I had a lot that was a buildable lot,
that means zoning doesn't apply to anything, because all lots at one point were pre-existing, right?
well, so
So the bylaw applies to all lots after it's enacted. So what it means is that it wasn't self-inflicted, it wasn't,
I understand, yeah, I will get, I'm with you.
but it doesn't mean that it's grandfathered. I think any lot that was created prior to zoning that has 50 feet of frontage and at least 5,000 square feet of area is grandfathered. Nothing else, I don't believe is. That's in your bylaw and statute.
So in this case,
So in the Crosby case, it was setback in building, it's not from. See.
Right, it was a requirement, it was a dimensional requirement. I found that I think I gave you a copy of the article, I think it was it was cited in a provision, in a report that related to frontage, and they cite that case because
in 1955, there was no requirement to have frontage, direct frontage on a public way or street.
anything.
Anything.
It was Wild West.
Yeah, I know. And
It was presumably created.
I just think it's so, this one is just so hard to understand why, because I'm probably one of the most lenient people here. I'm not a fan of anybody telling anybody what to do like anything. So I'm just, this one's, it hurts my hand.
It does.
Yeah, I mean, I would.
Yeah.
Based on what council has told us, I would have to say throw this at council and have it and really take a deep dive into it. Because based on what council sent us and I would love for you to give the information.
Kevin, I'd love to be able to, when you talk to council, say, the applicant's attorney is saying that the cases that you're citing are distinguishable because the bylaw says something different, or the whole factual circumstances are different.
We haven't heard from council on this at all, right?
No, we,
did, yeah.
Yeah, she sent over some stuff that was, citing the other way, saying that we can't grant based on.
So I choose this.
So if a lack of frontage is the circumstance that creates the hardship, then I agree, you can't grant it, but
So what is the hardship?
the circumstances that are creating the hardship are this crazy configuration that was created in 1950 when nobody saw it.
Be pre-zoning that.
It's not. So those cases are, I have a square lot that's identical to all the lots around it. It just doesn't have enough frontage. Well, in that case, it's the lack of frontage that's causing the hardship. Or I cut up my parcel to create that after zoning. So it was my decision to chop up my parcel into a crazy thing that doesn't meet the requirements of zoning that's causing my hardship, not the shape, topography, or soil condition. In this situation. So it shouldn't be that if in 1955, this family decided, instead of giving the fee interest in this little strip, they did it right away because it didn't matter. Those two scenarios end up with a different result. If he had granted, instead of granting that as a right of way, they granted the fee on that little strip of land to the owner of this, we'd be in a totally different circumstance. It doesn't make sense that you would interpret it that way.
There's a lot of lots that I agree, that
It just doesn't make sense. It's not a fair.
if you have enough land, the closeness you can get to the riverfront changes, right?
Yes.
Or by a line, right? So I'm with you.
So it just doesn't make sense. And so I would suggest to you that a lot of the cases that you're probably getting from council are distinguishable from this situation, both because the bylaws that the court are interpreting are different than yours, and because the circumstances of the parcel are different. And in those cases, it is actually the lack of frontage that's causing the hardship, not this crazy configuration that this family dreamed up in 1955.
But the configuration that you're talking about,
Situated to the behind the adjacent parcels. Not necessarily.
but it's a lack of frontage that is causing the inability to build on.
Right, so again, what I just said, we don't, so if you would feel more comfortable if they gave fee in that rather than have it be a right of way, it's the same situation.
Well, no, I don't know if I feel more comfortable. It would be, it would be real fun, right, like how now it's here. So it's a much easier. So, and not that I want to delay this any longer. I would like what we have for information to be shared. Well, this is just my opinion. And I'm a non-voting member.
So I don't need to know their opinions.
No, I know,
All I need to know is what cases they're saying to you.
That's what I'm saying.
I would be comfortable sharing that.
Well, all right, so I would like that information to be sent over to the applicant's council. As well as would like us to take that information back to our council, along with everything else that we have to really take a deep dive into this, because this is such a unique case. I don't want to, grant this, if the board was to grant it, to it just be appealed, and then everybody, and then it's just money out the window for everybody. I'd rather have a rock solid bearing that we can approve this, nor do I want to deny it and have it appealed, because we're still in the unknown, right? Because it's a little bit of a gray area. So if, I just suggest one more time, it will just happen, and with the intent that we're going to make a decision either way, so that we can move on.
Yeah, and I would just ask, when you discuss it with council, that they don't just give you a blurb that says, no frontage can't be a basis.
Well,
That they tell you why that.
Well, I think.
Okay.
they actually did quite a bit of work. I was doing
Okay.
a lot of research on this, and the message that I got back from council was, we're doing a lot of work here to either make it, go or no go. And if the argument, lies within your camp to prove to us, which you essentially started to do here, right, with Crosby. Because
Again, the reading of your bylaw, which doesn't contain, some of the cases out there have a requirement that every lot has frontage on a street.
Well,
Your bylaw doesn't say that.
it
No.
ties it circularly, like you start reading the drive. So if a driveway needs to be contained in, so.
That may be an adjustment, you might want to look at that, just see if there needs to be an adjustment to the variance, that as well. Because when you go and approve this, and then you can't get it because you can't put the driveway. Now,
Yeah.
we're
Now, that's gonna be like proving it in that variance.
So I would, if we can amend it, I don't know if you can amend it on the fly, but.
Yeah, and this
I don't know,
cross.
We're gonna have to republic, I'm not sure of the circumstances.
We need to figure that out, but I don't want to see you have to go through this all again, just for. We're gonna continue it and we can amend. I don't know the rule.
And so you definitely, I think,
Just for-
as far as predating zoning, I just need to understand what is the variance, right?
I'll make a
Remember,
motion to continue until next meeting, pending legal review. We want as part of that motion to allow, an access to the case law cited. Is that appropriate?
I mean, you got it here, you talk about Perez.
No. I don't think we need to vote to
Okay.
let's just send that information, we got to share that information. This is.
that's your job.
Is that public information?
Yeah.
It wasn't accepted.
And again, I'm not asking you to give advice to you, just like I can give you the kind of the case.
Make a motion to continue until next meeting, pending legal review. Of the circumstances related to, this.
Second,
All votes, all in favor?
Raleigh, aye.
John,
Clark, aye.
We have to ascend to the further continuance.
what's the date?
West State.
I think that would be March.
Or March 19th.
March 19th.
March 19th.
So continue to March 19th at 6 P.M., right? No other.
Yeah.
Nothing on the agenda currently. Yeah, whether or not, by then we'll discuss whether it's a modification of the request.
Not to file an amended
Yes.
petition.
I think,
Well, if somebody thinks that we have to republish, I would imagine what a notification was involved.
but again, right, it's a big.
Yes.
It's- We just denied based on information we had down, and the advice we had down. You have to go, spend a lot of money to appeal it and all that stuff. And we could take a little more time and just get it right one way or another.
Try to get it right.
It's,
Revenue.
just do like right.
And I know it's frustrating, because I was. Yeah, I think it's better to get it right. But I would also say that we could agree that, that we should have only the next meeting.
I agree.
That was you do cite the Perez case and how it's different with the Crosby case. So that was a good point. That was one way.
That's one of the things that,
There's a meeting.
yeah, I know.
That's why it was up here.
No, I saw that, going through, and we're sort of on something that.
Concom has a meeting up here.
So, yeah, I think the motion passed, so.
Motion to close.
I'll make a motion to adjourn.
I'm looking on a second.
What?
I have time to look at it. And we need.
Okay.
So, but it's just about a policy for.
Okay.
We have nothing to do with this.
Okay. So,
Thank you.
Thank you so much. Thank you.
So, and I'm talking about today, so when they came up with the decision that we have, or probably, I did, that we came in for, last meeting, that, the decision was, went through the appeal period, decision was pick it up, brought it down, we had it recorded, and then the engineer was putting together the A&R plans to the planning board, and realized that in the decision, we left out, and I didn't catch it. Anything different. And that was, Matt saw it to sign it, it's left out of the portion of something, right? Some which down the road, having to just move forward with it. And probably had anything with it, with selling the houses out. That would then cause, a title search, and I had to go and try to get that all fixed. Again, while you're trying to sell the houses, so, again, it's not that it's. I think it's fault, we all listed it, but a suggestion is that, and we already do this with the planning board, I believe at one time it was actually done with zoning, board, I think when I was on. That we actually asked the applicant's attorney or engineer to write the decision and send it in to us for review. That was the burden on them to get it right, not necessarily us.
Yeah, we used to do that all the time.
I don't know why we
So why we got away from it.
If the board was okay, would be okay with it, I would suggest that
So just clarifying how this works, so basically like this for that wasn't kind of the guarantee.
Oh, no, once we vote, approve it, then it's on them to write the decision and get it back to the board for review. And then, if there's anything missing, it can be sent back, say, hey, no, we have a revision, you needed shading, vegetation on the sides.
We used to do that all the time.
And I think that the nice part about it is none of us lawyers or engineers to be of that legal ease that needs to be in those documents needs to be so specific and airtight for when you sell property on the road that you're running across.
Yeah.
So if everybody's okay with it, I would just make that.
Yeah, I think that's.
I am.
Another thing that I've seen is we write a draft decision and it goes out to all interested parties for any comment. And then the next meeting it gets signed. Yeah, instead of, I don't mind going out.
Well, the only thing that
And I don't mind drafting it out either when I do it, so I usually draft them out.
the troublesome part, next meeting though, it's just the time, right? So that the next 28 years, it's just so much time involved.
Yeah, no, I'm just, it's,
Yeah.
yeah, it's really neat what's on. But it's good to have a draft, so you can send it out.
So who approved it? Like, what point is it sort of decided?
I would have to say that either we would give the chairman the letters and be able
So it's
to, I mean, we would all see it, and then we could all report back to Maya.
Oh, it's Mia, by the way, not to throw you off.
What is it?
It's Mia,
I'm
not to
sorry.
throw you off.
I saw.
It's the extra letter, I understand.
We just can't answer each other directly, but we through
Right.
Mia, we could
Mhm.
send it.
Fair enough.
And like I said, I have no problem drafting anything out or making it easier for you guys by writing anything. Just let me know what makes it easier.
That works for me.
Just to answer, I'm sorry, sometimes just mail out the decisions. No, Meta doesn't do that.
We never have.
So as soon as the decision gets filed with the town clerk, it gets mailed out, so that I would have it not on the day that it needs to be recorded. I would have it as soon as it's filed, so that I could look at it and maybe.
Oh, well, they did, but probably only 2 ones.
With the decision, everything just goes down to the town clerk's office.
So she said.
No, so actually technically speaking, no, he is right. None of the decisions get mailed out. I was told that they are supposed to go to the town clerk and then if you want a copy, you just have to send her a message and she'll give it right
You
over.
did.
No, I was told to just give it to Ellen.
They make the decision, they give it up.
I was told that only Ellen needed it and to have it in
Not the lot.
the office.
So the biggest maybe confusion on this now, so the clerk thinks it goes to the abutters, so that they would be, that they would know that they could appeal. So, all right.
I'll just do whatever I'm told. I'll start mailing it from now
No,
on.
no,
See, that might be helpful. Just
Yeah,
I
no
can see it,
problem.
and I don't have a chance.
No problem.
But even, we don't even have to physically mail it. You can email it.
I think
Or email.
You can post it.
Whatever works for anybody, I can do. I can email it, I can mail it, whatever makes it.
Just send it out to the parties in advance, they have an opportunity to look at it.
That's good. I'm trying to figure out how the town policy is.
Yes, thank you. I'd appreciate that.
PR, just making a suggestion.
Oh,
All right.
Motion to adjourn.
Favor?
Raleigh, aye.
Thank you.